You could. Perfect. So I'm here to introduce Patrick, and I'm going to do quickly so that he can give his presentation. Patrick is a housing team supervisor at Legal Aid of Sonoma County, where he manages legal aid's housing litigation and housing policy work. Legal Aid of Sonoma County is the county's largest provider for free legal services for low-income people. And in addition to housing, they work on issues of domestic violence, veterans benefits, guardianships, and legal issues for elders, among many other things. Patrick was raised in Sonoma County in Sebastopol and Monterey. He first did housing work in Baltimore, Maryland after college, and then decided to continue working with tenants back home after graduating from law school at the University of Michigan. Thanks for being here, Patrick.
Thanks, Adriana, and thanks to the whole NAACP chapter. Thank you to Kirsten for the invitation. What I am going to try to do is basically give a very basic primer of what tenant protections look like in the state of California. And then many of you have probably heard of the recent county ordinance that sort of augments or increases the state level tenant protections here in Sonoma County, at least in the unincorporated areas. So I'm going to go through those at a basic level, and then try to leave the most time that I can for questions if folks have them. So first I'm going to drop in the chat my presentation PDF form in case that's easier for folks. I do have a PowerPoint that I'll try to share here in a second. If you give me one moment. All right, let's see if I go to present. Can everyone see the presentation? Perfect, okay. So Adriana gave that wonderful introduction. My name is Patrick McDonell. I'm the housing team supervisor at Legal Aid of Sonoma County. So when we talk about tenant protections, there's sort of a whole realm of tenants' rights and tenant-landlord law. But generally, when we're talking about tenant protections, we tend to focus a lot on two areas. One is rent increases, which I'm not going to go into so much because the county's ordinance doesn't really impact that so much. The other part is displacement and eviction protections. And that's really where we're seeing a lot of the work around the state. A lot of the new laws are really going at that eviction protections, trying to keep people from being displaced. So displacement, when we talk about displacement, there are multiple forms of displacements that all sort of colloquially are called evictions, depending on the context of the conversation. So one form is what we call a constructive eviction. Constructive eviction is basically a place is so uninhabitable that the tenant is basically forced to leave for their own safety. The second category would be self-eviction prior to UD. That's where the tenant is quote unquote leaving voluntarily. Pardon me, UD is a term of art. It's unlawful detainer. Unlawful detainer is the legal term of art for eviction. So when I say self-eviction prior to unlawful detainer or prior to a legal eviction, it means that the tenant has received some sort of notice from their landlord saying they're required to leave. The tenant is getting out quote unquote voluntarily, not necessarily because they want to, and not necessarily because the landlord actually has the right to evict them, but they're not going through the legal process. The sheriff isn't the one that's actually escorting them out. And then the final category of eviction would be a formal eviction, which is going all the way through the legal process. When we look at displacement around our county, around the country, we see numerous negative effects, really strong correlation with negative health outcomes, community destabilization, right? These are people who are invested in their communities. When they're evicted, they're gone. All that investment, all the bonds that those people hold disappear. And there's increased racial and gender disparities, both in who we see getting evicted and then also the impacts of being evicted after the fact. Eviction is not something that is, it's not a social issue that is borne equally across all races and genders. It is an issue that overwhelmingly affects women, especially single women, and especially single women of color. When we talk about formal evictions, this is the legal process, so it's that third category. There are basically three main stages. It always starts with an eviction notice. Then there's the unlawful detainer filing. So the landlord goes to court. They actually do a court filing or a lawsuit to initiate the case. They have to go to court. They have to prove their case. And then after the fact, if they get a judgment against the tenant, they go to the sheriff, and the sheriff is the one that actually conducts the lockout of the tenant. So talking really quickly about the state protections and the legal baseline that we're starting from when we look at what the county and local jurisdictions have done. The legal baseline, which can sometimes surprise people, is that if a tenant is on a month-to-month lease, which includes a lease that might have been a year, but the year is now up, we're in month 14, 15 of a year-long lease, that tenant can be terminated at any time, for any reason, or for no reason at all. So the landlord does not need a reason to evict a tenant who's on a normal month-to-month lease. They can give no reason, 60-day notice, that tenant has to leave. What the state did in 2019 is they said in the middle of a housing crisis, it is frankly a bit absurd that a tenant who is complying with all the rules of their lease can still be evicted at any time for no reason at all. So they instituted what are called just cause protections at the state level. Just cause means that the landlord has to have a reason to evict the tenant. Those just cause protections apply after 1 year of tenancy. The tenant has to live in the unit for a year. And there are two kinds of just causes for eviction. There's no fault just cause, which means the tenant has not done anything wrong. There's no reason why, because of the tenant's actions, the tenant is going to be evicted. So those are like when the landlord is renovating the property, landlord is moving a close relative in, or the landlord is going out of the business, selling the property, not going to be a landlord anymore. If the tenant is not at fault, the landlord has to provide relocation funds, which under the state law is equal to 1 month of the rent. Then there's at fault just cause. This is the tenant isn't paying the rent, the tenant is causing property damage, et cetera, et cetera. At fault just cause means that the tenant can be evicted on a 3-day notice. Depending on the violation, they might have 3 days to cure, meaning 3 days to fix whatever it is that they've done wrong, pay their rent, stop doing whatever's in violation of their lease. And if they don't do those things, then the landlord has the right to proceed with an eviction. Now, these just cause protections apply to largely multifamily complexes. They do not apply to single family homes, subsidized housing, or housing that is less than 15 years old. So when you go through those three categories, you capture the majority of tenants who live in Sonoma County, largely because of the single family home exemption, which is to say that if you live in a single family home in Sonoma County and you're on a month-to-month lease, most likely these protections don't apply to you. Same with subsidized housing, and same with housing that's built within the last 15 years. So I'll briefly run through the data. Part of the reason I showed or shared the PowerPoint is I want folks to have the information and really be able to go through the information quickly and then save time for question and answers. You have the number of unlawful detainer filings. I picked 2019, 2021, and 2023. So you can see pre-pandemic, a year during the middle of the pandemic, and then kind of where we were post-acute pandemic. And you'll see that in 2019, we had about 939 eviction filings. So these were landlords that went to court, filed a lawsuit against the tenant asking for the removal of the tenant. 2021, we had a lot of eviction protections. We had rental assistance program. We went down to 337 filings, so a huge drop, right? 2023, post-eviction, we go back into that low 900s number. And so the thing that I want to take from this data is that what we saw with the COVID era protections was that we had a huge drop in eviction filings, which was the stated goal. And then after those protections expired, we didn't see an enormous spike. right? We saw basically the eviction filings return to where they were before the pandemic, which tells me something, and that is that the quote unquote necessary evictions, there wasn't a huge backlog of necessary evictions. The evictions that, we all hear about, these horror stories with tenants who cause property damage, they don't pay their rent for months and months and years even, right? Those evictions were able to go through during the pandemic. If those had truly been backlogged because of the protections we had during that period, you would have seen a big backlog and a big spike in 2023 when those protections expired. Sheriff lockouts, you see basically the same thing, low 500s in 2019, mid 400s in 2023. Again, no huge backlog in evictions, no huge spike once the protections came down. So there are different kinds of evictions, like I was saying. The 3-day notices are when tenants have done something allegedly in violation of their lease, they haven't paid rent. That's about 62.5% of the cases that we see at legal aid. 30-day notices are the tenant is not at fault. That's 13.5% of the notices we see. 60-day notices, those are for generally no fault, just cause evictions or no cause terminations, right? So the tenant has either not done, well, the tenant hasn't done anything to legally merit eviction, and the landlord either has a just cause or thinks they have a just cause, or hasn't stated a reason at all, right? So those 60-day notices where there's no fault of the tenant, that's 18.3% of the cases or the notices that we see at legal aid. Then we have about 5% that are other categories. So the takeaway here, right, is that when we're looking at displacement in the county, about 18.3, and because the 30-day notices, that category includes a lot of folks that are being evicted for no fault of their own, right? So somewhere north of 20% of evictions that we see in Sonoma County are not due to any fault of the tenant. So the county has come in and decided to build upon the state law and the state level protections with their new ordinance. And so I'll explain briefly kind of how they've taken what the state law does and increased it for folks that are in unincorporated Sonoma County. So you might remember that in the state law, the Tenant Protection Act, those just cause protections, they only apply after 1 year of tenancy. The county has said that those protections now apply from day one. So as soon as a tenant moves into a property that is otherwise eligible for the protections under the Tenant Protection Act, those protections apply day one. If the landlord wants to evict on day two, they're going to have a reason. The relocation fund, the relocation funds, under the state law, it's equal to 1 month of rent. Sometimes you have folks that are paying below market rent, and the amount that they would get isn't enough to really do anything meaningful in terms of them relocating. The county has changed that so that the relocation funds, if the tenant isn't at fault for the eviction, is the greater of the fair market rent for a unit of that size or the actual rent. So with the exemptions that I mentioned, right, the properties that don't have these protections, the county has left the exemption in place for single family homes. So these protections still don't apply to most people in single family homes. They do apply to folks that are in subsidized housing. That's the one that the county changed. They took the exemption away from subsidized housing providers, saying that, the folks who live in subsidized housing are some of our most vulnerable residents. We want to make sure that we're protecting them. So subsidized housing, that exemption has been removed. Housing that's less than 15 years old, that exemption has remained unchanged. So if you live in a newer complex, a newish house, these protections would not apply to you. Prior to the county's ordinance, there was no systematic tracking of eviction notices at all in the county. The county does not know how many rental properties that exist in the county. They don't know where they are, what type of property they are. They don't know who's getting evicted or why. Now the eviction notices are going to be tracked for all properties in the county, whether or not the ordinance or the state law applies. So every rental property in the unincorporated area of the county this doesn't apply inside the city limits of Santa Rosa, Petaluma, Roanoke Park, what have you, but outside the city limits, all landlords, when they terminate a tenancy, are going to have to go to a portal set up by the county and upload their eviction notices so that the county can finally start getting data on who's getting displaced when and where. And then the last bit, or one of the last bits, and this is the one thing that applies throughout the county, is that the Tenant Protection Act doesn't say anything about emergencies. It was passed actually before COVID came into effect. It was just sort of coincidentally took effect at the beginning of 2020, right before we went into pandemic mode. The county has, in its ordinance, created an emergency moratorium based on the COVID protections that they can declare or put into effect throughout the county, including inside the city limits, when there is an emergency and the county board of supervisors wants to reach for their emergency powers. The idea being that when the hills are on fire, when there's a pandemic, is not the time when you want to be debating the merits of a policy like this. You want to have that lever ready to pull when the emergency comes. Eviction notices are also required to be in both English and Spanish when a property is covered by the new ordinance. And for non-payment of rent cases, a tenant cannot be evicted for less than 1 month of rent. So if you owe less than 1 month of rent, that is not cause for an eviction. As soon as another month becomes due, right, that becomes a cause for eviction. And so that, you know, a tenant can't just constantly be like $800 in debt. They're only allowed to use that twice a year, right? So they can't carry over a rental debt for months and months and months. It's basically you lose your job, you fall a little bit behind, you're doing your best. This gives you some breathing room to get caught up without, you know, unduly burdening the property owner. So the gaps that still exist from our point of view, right, is there's no mechanism to prevent bad faith withdrawals from the rental market when a property owner goes out of business. They can basically say that they're going out of business, and then as soon as the tenant is out, re-rent the unit at a higher rate. That is, largely speaking, legal, or to the extent that it's illegal, it's extremely hard to prove. There are jurisdictions that have mechanisms to prevent that. Sonoma County does not. There's no special protections for families, moving in family members when, you know, grandma has health issues and needs to come live with the family. There's no special protections under the county ordinance for that. There's no broader rental registry for more significant data on the rental housing market generally. Again, the county doesn't really know much about its rental housing market because it doesn't have any sort of systematic data collection or tracking. What we have is tracking now of eviction notices that'll start in 2025, but no more general tracking or data on the residential housing market. And then there's no anti-harassment or anti-retaliation protections that do exist in other jurisdictions. So those are the kind of the gaps that still exist that we see, at least from our perspective, at Legal Aid. So the last thing that I wanted to highlight before I go on to questions is that we put together, with help from North Bay Organizing Project and from NAACP, an eviction mapping project that shows you where evictions are happening, at least in terms of eviction filings and the actual sheriff lockouts. Again, because the data from the county hasn't started to come in on the eviction notices, we really don't know where people are being evicted from at that stage. We just know where people are filing lawsuits, where the sheriff is going to lock people out on the very, very end of everything. But this website, which is linked in the PDF, The Struggle for Home, shows you where those UD filings, those eviction filings are happening by zip code, sheriff lockouts by census tract, and we overlay different racial, demographic, socioeconomic data so you can see, you know, not only where these are taking place, but in what kind of neighborhoods are evictions taking place. What do the neighborhoods look like? How dense are they? Who lives there? So we can really get a sense of where displacement is in our community and who it's taking the biggest toll on. And so lastly, this is the contact for the legal aid housing hotline. So if folks are in a situation where you receive an eviction notice from a landlord, you have a friend who's has received an eviction notice from a landlord, or has questions, issues with their lease, that's the number to call to get our help for the housing team at Legal Aid of Sonoma County. And for those who are looking at the PDF, the text of both the Tenant Protection Act, which is the state law, and the local Sonoma County ordinance is linked in the presentation. And that's it for me in terms of content. And with whatever question or whatever time I have left, if I have any time left, I'm happy to take questions.